Izati, and I'm the CEO and co-founder of Spark Innovation Limited.
My name is Nur Aqila, CFO of Spark Innovation Limited.
I am Irina, and I am the founder of Irina & Co, specializes in corporate law.
I'm Oviapaavai, the co-founder of Irina & Co, specialized in winding up matters.
Hi, good morning, Ms. Izati. Ms. Aqila, please have a seat.
Thank you for the both of you to see us on such a short notice.
It's our pleasure. I hope it's not too hard to get to the firm given the construction outside.
Okay, so before we begin, traditionally, we will explain a little bit of how these meetings run. And if you have any questions, feel free to ask us, okay? Okay, so the first and most important thing that we need to discuss is confidentiality. So are you aware of this term, confidentiality?
I'm not.
Okay, so essentially, confidentiality means that any information that you share with us will strictly stay within the four walls, okay? So we emphasize this at the outset to encourage you to provide us with candid and thorough information. Okay, so there are, however, very few instances that we would be required by the law to disclose certain information. So should such a certain situation arise, we will inform you promptly and as you remain in control of this process. So do you have any questions so far?
No questions.
Okay. Before we begin, may I inquire if you have any time constraints?
I'm not.
We aim to make this session as comfortable and informal as possible, as it is essential for us that you feel at ease to share your concerns. The more you share, the better we can understand your situation and provide effective assistance. I would also like to mention that there are two of us present today. I'm Ovia here, and my partner, Miss Irina. This ensures that if either one of us is unavailable in the future, you will still have someone familiar with your case who can assist you.
Thank you.
Additionally, we hope you don't mind if we take some notes during the consultation. For your convenience, we have provided paper and pen that you can jot down anything during our discussion. Do you have any questions or concerns before we proceed?
I'm not.
Okay, so it is also important to note that we will not be doing anything without your permission. So if we are going to go and do some work on your behalf, we will be letting you know that we will be taking these actions. And after computing, it will probably be costing about this much. Okay, and then you have the decision as to whether or not we should go forward. Okay?
Alright.
We understand that Spark Innovation Limited is going through a difficult time. How can we assist you today?
Our company has decided to voluntarily wind out. We are here to understand our options and ensure we are making the right decisions for the company, our employees, and ourselves.
Of course. Okay, to start, could you give us a brief overview of the current financial situation of your company and what exactly happened?
So over the past 2 years, our company Spark Innovation Limited has met these various challenges. These challenges have severely impacted our financial stability and operational viability. And amongst the main issues that we face is the intensification of this competition within our own tech company, right? And in this tech industry, as a mid-sized company that we are right now that specialize in AI solutions, we initially thrive in this a very dynamic kind of market, right? But over the time, as we proceed, we notice that there is a problem here, and this problem has something to do with the landscape. Landscape that has evolved rapidly with the new entrant disrupting our traditional business models and also established players expanding their own offerings into these dynamic markets. Understandable.
In addition to heightened competition, we have experienced setbacks stemming from unsuccessful product launches. Despite our diligent research and development efforts, Some of our key projects failed to resonate with target markets or encountered unforeseen technical obstacles. These setbacks not only depleted financial resources, but also eroded investor confidence and brand reputation.
Should I also add that there has been instances of a funds mismanagement within our own company, that although our intention was always to allocate resources prudently and to maximize the returns, there are certain decisions and actions that has unfortunately still led to inefficient spending and resource allocation. And this mismanagement that we encounter has worsened our financial challenges and hindered our ability to navigate through this very turbulent market conditions as we would like to be effectively, but it does not.
Despite concerted efforts to implement strategic measures and cost corrections, we regrettably have not been able to achieve the desired financial turnaround. The cumulative impact of these challenges has placed significant strain on our cash flow, profitability, and overall financial health. As a result, the board of directors conducted a comprehensive review of our options and concluded that voluntary winding up may be the most prudent course of action to address our mounting debts and facilitate an orderly distribution of any remaining assets to stakeholders.
And due to that, we find it important to emphasize that this decision we made was not to be taken lightly. And we strive to recognize the implications for our employees, investors, and our business partners, right? And but in the absence of these practical alternatives, as well as considerations towards our fiduciary responsibilities, the board has agreed upon the company's winding out to ensure the interest protections of all people, and also to mitigate further financial deterioration that we face.
I see. Given these circumstances, we have few pathways to consider. First one is voluntary winding up, then compulsory winding up, or exploring corporate rescue mechanisms. Let's start with voluntary winding up, as it's already unstable. This process involves the shareholders passing a special resolution to wind up the company voluntarily. This can help you to control the process more effectively compared to a compulsory winding up, which is initiated by the court.
Okay, so during voluntary winding up, a liquidator will be appointed to settle the company's debts and distribute any remaining assets to the shareholders. So one of your concerns might be the impact on your employees, right?
Yes.
So while it is unfortunate that winding up usually results in job losses, the liquidator, however, will ensure that employees receive any entitlements that they are owed, and such as unpaid wages and severance. Okay.
What about personal liability for the directors? Are we at risk?
Generally, directors are not personally liable for the company's debts unless there has been wrongful or fraudulent things. If the directors have acted in good faith in the best interest of the company, personal liability should not be a concern. However, the liquidator will investigate the company's affairs to ensure there has been no misconduct.
I see. Well, we are also interested in exploring any possible restructuring opportunities. Are there any possible ways to save out the company without resorting to winding up?
Okay, of course. In situations where winding up may not be the only viable option, there are alternative mechanisms designed to facilitate corporate rescue and rehabilitation. So, two prominent options are the corporate voluntary arrangement, which is CVA, and judicial management. So these mechanisms offer a structured framework for companies to address financial distress while endeavoring to preserve their operations and value. Okay, so a CVA is a contractual agreement between the company and its creditors, overseen by a licensed insolvency practitioner. Okay,
Yes.
Okay, so this arrangement allows the company to propose a repayment plan to its creditors, outlining how debts will be repaid over a specified period, typically 3 to 5 years.
Okay, so the proposal must be approved by a voting majority of creditors, providing a mechanism for the company to negotiate favorable terms and avoid immediate insolvency proceedings. Do you guys catch it so
For
far?
the CVA,
Yes.
yes.
Okay.
Thank you.
One of the key advantages of CBA is that it enables the company to continue operating while restructuring its debts. By entering into a CBA, the company can benefit from improved cash flow management, reduce credit pressure, and the opportunity to focus on operational recovery and growth initiatives. Plus, a successfully implemented CBA can help preserve jobs, maintain customer relationships, and safeguard the company's reputation within the market.
Thank you for the explanations and details, Mrs. For the interest of our company, I'm in view that the CVA explained earlier seemed to be a very promising avenue for us to explore. And with that, our company also had the objective of distraction management, minimization, and to maximize this value of all stakeholders. And so, preserving the company's operations and reputation. Uh, we believe that this will be in line with our objectives that we have. And therefore, we would like to further discuss the feasibility of implementing the CBA and the steps involved in proposing and obtaining these creditor approvals. And I also believe that my partner also agreed with me on this one.
I agree. The prospect of continuing our operations and addressing our financial obligations through a structured repayment plan is reassuring. However, I'm curious about the practicalities of negotiating with creditors and formulating a viable proposal. How would we navigate potential challenges and ensure that our proposal is accepted by the majority of creditors?
Judicial management involves the appointment of an independent judicial manager by the court to assume control of the company's affairs. The primary objective of judicial management is to restructure the company's operations, finance, and the management with the aim of achieving a sustainable turnaround. The judicial manager, who is typically a qualified insolvency practitioner or experienced business restructuring specialist, assumes powers to manage the company's affairs, including the ability to negotiate with creditors, restructure debt obligations, and also implement operational changes.
Yes, and judicial management provides a more intensive intervention compared to a CVA, as it involves direct oversight and intervention by the court. So the judicial manager operates under the supervision of the court itself and is empowered to implement decisive measures to stabilize the company's operations, addressing underlying financial issues and formulate a viable restructuring plan. Okay, so while judicial management requires judicial approval and imposes stricter legal requirements, it offers a robust mechanism for companies facing severe financial distress to pursue comprehensive restructuring efforts under the court supervision. Lah. Okay? Yes.
Thank you. I find this concept of judicial management is quite intriguing, and particularly the potential for a comprehensive restructuring under the court supervision. But the involvement of the court and the stricter legal requirements raise some questions about the process and the timeline for it. How would the appointment of a judicial manager impact our day-to-day operations and decision-making authority as a directors? And what level of cooperation would be required from creditors and other stakeholders during this process? Can you enlighten me?
I share similar concerns. While judicial management offers a more intensive intervention, the prospect of relinquishing control to a judicial manager and navigating legal complexities warrant careful consideration. It would be helpful to gain a clearer understanding of the practical implications and potential challenges associated with judicial management before making a decision.
Yes.
Both the CBA and judicial management offer valuable avenues for companies to navigate financial distress and pursue corporate rescue initiatives. The choice between these mechanisms depends on various factors, including the severity of the company's financial situation, the level of creditor support, and the extent of operational restructuring required. As legal practitioners, we would assess the suitability of each option based on your company's specific circumstances and objectives, guiding you through the process and advocating for the best possible outcome.
Yes, and these options can help you avoid insolvency and potentially save the company. However, they require the approval of creditors and a viable restructuring plan. So we would need to assess whether Spark Innovation Limited can realistically be rescued through this means.
Okay. What is the timeline for this process? Whether we proceed with the winding up or corporate rescue?
Voluntarily winding up can take several months to over a year, depending on the complexity of the company's affairs. Corporate rescue mechanisms like a CBA or judicial management might take a few months to set up and longer to implement fully. The timeline will depend on the various factors, including creditor negotiations and the effectiveness of the restructuring plan.
And to proceed, we recommend conducting a thorough review of your financial situation and discussing the viability of CBA or judicial management with your creditors. If winding up remains the preferred option, we'll guide you through the necessary steps to ensure it's done correctly and with minimal disruption.
Thank you both of you for your guidance, and we'll need some time to discuss internally, but we do appreciate the clarity of our options available.
Yes, thank you. We'll be in touch soon to report.
You're welcome. We're here to support you through this challenging time, and please do not hesitate to reach out to us if there are any questions, okay?
Take care and we'll await your decision.
Thank you.
Don't forget this.
Oh, this is your
Okay, well, that was quite an insightful consultation with Miss Izati and Miss Aqila. So Spark Innovation Limited is facing some significant challenges, but they seem determined to explore all the available options, aren't they?
Yes, indeed. Their decision to voluntarily winding up the company reflects a pragmatic approach to addressing their financial difficulties. However, I believe there are potential alternatives worth considering, such as judicial management that we proposed earlier to them. It's essential for us to thoroughly evaluate each option and provide informed guidance based on their specific circumstances.
Yeah, I agree. And in addition to that, we should also explore all the potential avenues for restructuring and a turnaround. For example, debt restructuring initiatives such as debt to equity swaps or debt forgiveness agreements could help alleviate immediately financial pressures and improve the company's balance sheet.
That's an excellent point. Debt restructuring measures can provide breathing room for the Spark Innovation Limited and allow them to renegotiate more favorable terms with creditors. Additionally, exploring strategic partnerships, joint ventures, or mergers and acquisitions within the tech industry may offer opportunities for synergies, market expansion, and access to additional resources.
Yeah, absolutely. By diversifying their strategy options, Spark Innovation Limited can maximize their chances of achieving a successful turnaround and long-term sustainability. So we should present these additional options to Ms. Izati and Ms. Aqila during our follow-up meeting and assess their viability in conjunction with the CBA and judicial management.
I agree. It's essential to provide a comprehensive overview of all available alternatives and their potential benefits and risks. Our role is to empower Ms. Izati and Ms. Aqila within the information and support they need to make informed decisions that align with the best interest of the company and its shareholders.
Yeah, all right. So I will incorporate these additional options into our analysis and prepare a comprehensive report outlining the pros and cons of each approach. Okay, so let's ensure we present a well-rounded and strategic roadmap for Spark Innovation Limited to consider during the follow-up meeting.
Sounds like a plan. We'll leverage our expertise and industry insights to develop tailored recommendations that address Spark Innovation Limited's unique challenges and opportunities with a collaborative and proactive approach. I'm confident we can help them navigate this complex landscape and emerge stronger on the other side.
I agree. So let's reschedule the follow-up meeting for early next week. So in the meantime, I will finalize the report and circulate it to your for your review. If there are any additional insights or considerations you would like to include, please let me know. Okay.
Will do. I'll also reach out to our network of financial and industry experts to gather any relevant data or perspectives that may inform our analysis. We are committed to providing Ms. Izati and Ms. Aqila with the support and guidance they need to make well-informed decisions for this Spark Innovation Limited.
Excellent. So let's stay proactive and focused on our objectives. I'm confident that together we can help Spark Innovation Limited navigate this challenging period and start a course toward a brighter future.
All right, thank you for your collaboration, Irina. I look forward to our continued efforts in supporting our clients and delivering positive outcomes.
Likewise, Ovia, let's make it happen.